This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Please take the last recital at page 71. And whereas this scheme aims to provide interim relief by way of livelihood support and social security on humanitarian grounds to the aforesaid distressed families of non-teaching staff in Group C, Group D categories until the final adjudication of the review petitions or appropriate application by the Honorable Supreme Court. Then, my lord, your lordship may kindly take, my lord, the page 72, paragraph 6 of the scheme. First is, my lord, an eligible non-teaching staff in Group C, Group D belonging to a distressed family shall be entitled to, etc., as livelihood support for his/her distressed family due to sudden unemployment and on humanitarian grounds with effect from so-and-so and whose salary has been discontinued. The benefit shall be discontinued upon occurrence of so-and-so, so-and-so. Any of the following, whichever is applicable or occurs earlier. Of which, my lord, item number III is, my lord, conclusion of the Supreme Court proceeding. Yes, and 5 is, my lord, on securing some other livelihood. Therefore, my lord, the scheme itself is, my lord, interim in nature. Scheme refers to the Supreme Court review petition. Scheme again says that it will come to an end once the Supreme Court takes a final call on the review applications or whatever are pending.
Tell me one thing.
Yes.
The amount has been fixed at rupees
20 and 25.
25,000.
Yes.
20 and 25,000.
Right.
How did you fix up this figure?
But I think it is for the C, it is.
So the salary amount you've taken as the base rate or something.
But on this, right now, I'm not in a position to assist you.
And how many candidates' jobs were set at naught by the order of the Supreme Court? Who will be the beneficiaries? The figure?
C and D.
And page 71,
Yes, ma'am.
the third recital
Yes, ma'am.
mentions about a similar incident in the past.
Yes.
What are such similar incidents in the past where the financial benefit has been granted
Well,
to...
there has been a lot of instances, may not be for relating to employment. To my knowledge, say, for example, my lord, puja donations.
No. Those
Say,
are
for
separate.
Yes.
Those
No.
are
But these
separate.
are because 282, my lord, the attention of the court has been drawn to 282. Therefore, my lord, I am saying, my lord, these are all, my lord, come, my lord, under different heads from the consolidated fund, and, my lord, different separate account numbers are required to be, my lord, maintained. And there's another judgment, but right now, my lord, I don't recall, where, my lord, our High Court has held in regard to the expenditure from the consolidated fund. It is not for a judicial review by a writ court. I'll get that judgment because I was possibly, my lord, addressing the division bench on that. In a PIL, my lord, that was held.
Regarding the
financial expenditure.
Honorarium granted to the
Very many was there. Very many
Muslim priests or something.
Yes.
There is one order.
Yes.
Right. But tell me, so you are not aware as to why this 25,000 has... And the assistance that you will be giving to these people, will these people give anything in return, or they'll sit at home and they'll earn the money?
My lord, here, my lord, because of, as the scheme says, because of sudden loss of livelihood.
That means somebody will stay at home and you will go on paying the money till the Supreme Court decides an issue. And how long will the issue be said to be pending before a Supreme Court? Because one after another review petitions will come. There will be no end. You cannot stop anybody from filing a review application.
That is for the Supreme Court to consider how long will the Supreme Court will entertain.
And no, your petition says it will continue till the matter is pending.
No, still, my lord, this review applications, my lord.
So one after another review applications will come.
No, Millard, please have a look to Millard.
Second paragraph, filed review petitions before the Supreme Court. Central School Service Commission has filed review petition. Right.
No, it's only Millard, the state government, the first recital. Please have a look at page 70.
Yes.
The state government, along with the School Service Commission, has filed respective review petitions before the Supreme Court.
Yes.
Yes. So it is only Millard, the review applications which has been filed by the state and Millard Commission, which is taken note of in this scheme.
No, but then what will be your submission with regard to paying 20 or 25,000 rupees to a whole lot of candidates who are sitting at home and not doing any work? Public, you are spending public money for it.
Yes. Yes.
And to candidates whom the Supreme Court has specifically used the...
May I say this? Yes, I got your Lordship's point. My first response would be, Millard, that Millard, at the instance of Millard, the writ petitioners, Millard, with respect, Millard, kindly do not take me amiss. Possibly, Millard, this point cannot be raised by the petitioners. That if I am not getting, why is he getting?
No, he is not getting. He is waitlisted. No question of
Therefore,
it.
Millard, if he or the petitioners over here cannot get, then Millard, the petitioners does not have a cause to pursue before this court.
So you want somebody who were there in the Supreme Court to come here and challenge this? Who could be the, according to you, the challengers to this scheme?
Millard, may I say this, Millard? Today, Millard, we are concerned about the writ petitioners. But if the writ petitioners either have a right or they don't have a right. If they do not have a right, Millard, then whether tomorrow somebody will come or somebody comes at my liking is something different. If they do not have a right today, Millard, in my very respectful submission, Millard, this petition cannot be
maintainable. All right.
Entertained. Because, Millard, your Lordships have held, Millard.
Yes,
mandamus is, Millard, for infringement of an established right.
Anything in reply?
No, 1995. 1995. যেটা ও রিলাই করলো
99.
Now, the deepest of respect, learned advocate general probably.
The first demurrer was locus standi. It is not a pill; it's a writ petition.
This writ petition by a person who was a candidate. After cancellation of all appointment method, all persons come to the same footing. There you cannot make a classification. That's the first point for a writ petitioner, which comes under Article 14. I am not, therefore the locus standi petitioner cannot be questioned at all.
Very well.
Secondly, one important aspect which you wanted to raise kindly takes up 1999 5 SCC. I have not cited judgment, but if necessary, there are judgments, I will cite it. But let me rely on his own judgment, which is relied upon. First of all, this has no 141 application. Kindly first
144.
No, 1999 5 Supreme Court cases, page 733 does not decide any law which has binding nature to this court under Article 141. What does the court say? Let us see. May I just place it? Paragraph 4. We are rather concerned to note that the writ petition number such and such has been entertained by the Lucknow bench of the Allahabad High Court. That writ petition is directed, kindly see, against an auction sale of house number such and such, and seeks an order to the effect that the auction sale be not confirmed. The learned single judge of the High Court has noticed in the interim order that auction was being conducted under the orders of this court, and the matter concerning auction of the house was pending in this court. Therefore, the question of amity of judicial discipline comes. In our case, this is a new cause of action. You prepare a scheme after the judgments have become a concluded effect. Mere filing of review application does not legally entitle somebody to say that the
list is pending.
Only after the review notices are issued, and the Lordship knows, as so from my experience, I can tell you, Lordship, the Supreme Court review applications are not hard. This is decided by the honorable judges in the chamber. That's why they use this method of filing MA applications, and which have been repeatedly dismissed by the Supreme Court. That indicates the Supreme Court has reached its final conclusion. After that, this scheme, well, Article 162 does not empower you, I have argued this, to negate a judgment of the Supreme Court in any manner. The judgment declared by a court can only be changed by way of a legislation removing the foundation of the judgment. That is the settled principle. I don't have to argue. Even in this court, we had got the Cooperative Societies Act ultra vires declared. Then they passed a legislation taking out the grounds on which this was declarative ultra vires and passed another law, which is also under challenge. That's a different thing. Therefore, that is the settled law. Therefore, 162 does not empower you to legislate in the form of executive action to negate a Supreme Court judgment or even negate a High Court judgment. And this scheme is specifically maintained for the persons who have been found to be corruptly appointed. Can the state, in any form, giving in the name of relief, support corruption? This is the first question. The second question was that not only they have been found to be corrupted, this direction of the High Court to upheld by Supreme Court that they have to return the benefit of money which they have earned so long. And instead of getting the money returned from them, you are trying to support them out of public fund. This is the question of the constitutional morality again comes in. And in this context, Lord, I would like to cite one of the decision of the Supreme Court where the then Chief Minister of UP, Mr. Mayawati,
106. (106)
2012 8 SCC 106. Here below, the CBI started an investigation saying that the Supreme Court directed. The petition was filed. From that, it went up to the Supreme Court. Supreme Court says, entire thing is quashed. Because you cannot take, in the name of Supreme Court, start doing something which is not under the order of the Supreme Court. This is the basic principle of this judgment. I just kindly place before Lordship the relevant portions. 2012 SCC, page 106. Now, after discussing everything in detail, now the Supreme Court says 41, kindly come to paragraph 41. We finally conclude that anything beyond the Taj Corridor matter was not the subject matter of reference before the Taj Corridor bench. That is the Supreme Court bench. Since the order dated 18 September 2003 does not contain any specific direction regarding lodging of FIR in the matter of disproportionate assets case against the petitioner, CBI is not justified in proceeding with FIR number so and so. In view of the above discussions, we are satisfied that CBI exceeded its jurisdiction in lodging an FIR in absence of any direction from this court in the order dated so and so or in any subsequent orders. And then ultimately squashed. Here, my lord, I have been facing repeated orders of the Supreme Court saying, no, we are not interfering 3rd April. And by repeated application, as it is also mentioned in the scheme, the review applications filed by the SSC and in future it might be filed. You are adopting very unfortunate tactics to waste public fund to protect the corrupt people. That everybody has jurisdiction, and because the Reed Court, where the fairness of the administrative action, Article 14 is very important.
Page 71.
71, kindly turn to page 71. And my lord has noticed it, that's why he was referring to.
And whereas second last
And page 70, and whereas the scheme aims to provide interim relief by of livelihood support and social security. Livelihood support, social security under Article 41 does not remain to a particular group. On humanitarian grounds, to the aforesaid distressed families of non-teaching staff in Group C and Group D categories until the final adjudication of the review petition and appropriate application filed before the Supreme Court or any other further petition has been filed. Twice attempt was made. And again, will I say, there is no review application pending for consideration. Mere filing with the registry does not entail consideration by the court. In that background, I would logically stay the entire scheme. My juniors insisting me just to point out to your lordship paragraph 9 of the petition, how will his locus is maintained. Stop that. It's not Kicho. That's what Joy can do.
Very well.
But only one factual correction, because in reply, I am not supposed to say anything. Milord, the submission made by Mr. Bhattacharya that they have to return the salary, but that is, Milord, factually not correct. Kindly have a look to page para 46, page 60, 45 and 46. However, Milord, candidates who are already employed need not be asked to refund.
These are for the teachers. The scheme is for non-teaching staff.
46 does not, Milord, make any distinction between Group C, Group D and teachers.
Those who are already employed need not be asked to refund.
Yes.
Right.
Yes.
So you are not giving money to the candidates who are already employed. You are giving money to the candidates who have been terminated.
But my submission is, Mr. Bhattacharya in reply that Supreme Court had directed refund.
Yes.
So that, Milord,
but paragraph 45 says they should be required to refund any salaries received. Then?
But 46, Milord, does not make any distinction between the C, D or Milord teachers.
Please.
Very well.
Whatever the Supreme Court has said, the Supreme Court has said in the order. Whatever.
But one more thing, Milord.
Yes.
Mr. Bhattacharya submitted that filing of a review application does not mean that the Supreme Court is
in CC of the matter.
Number one, Milord, the division bench has said that the Supreme Court is in CC over the matter.
Yes, you've
and
submitted
number two, Milord, there is a judgment of Justice Rumapal. Milord, I don't remember, the page was 555. That's why I remember the page number. Where, Milord, in the context of a contempt application, Milord, our court held that once something is filed in the department, the court or the matter becomes sub judice before the court. Then, Milord, the court may allow it, may dismiss it, whatever it is. But Milord, once it is filed in the department, the matter becomes sub judice. If required, I can give that judgment. But over here, Milord, our division bench in the context of this matter has said
that is correct. That was in respect of limitation of contempt application. That since it is filed, limitation will not run.
Yes, but so yes.
Limitation ছিল contempt 1 বছরের মধ্যে অর্ডার ছিল বলে ফাইল করলে পরে
and Milord, salary possibly Milord anyway, salary amount was much higher, I'm told, than Milord 20,000 or 25,000.
And that is basic.
So these people will be receiving either 20 or 25 sitting at home.
Basic.
Sitting at home.
If tomorrow, Milord, the Supreme Court dismisses the review application, matter ends over there.
Till the Supreme Court dismisses, the person will be paid.
That is expressed in the Milord
scheme itself.
I cannot, Milord, make any submission contrary to that.
And whether similar type of schemes are extended or thought of by the state in respect of so many unemployed candidates?
No.
Only in respect of the candidates
unemployed
orders
yes.
whose appointments have been set at naught by the
Supreme Court can take care of that, Milord.
No, you are the state. You will take care. Supreme Court is not framing the scheme.
Milord, I have raised, Milord, a legal issue That when it is,
Hmm.
my lord, concerning the Supreme Court and in response to the submission
Yes, I followed it.
that the Supreme Court's order is being subverted, but my submission is, my lord, it has to go before the Supreme Court.
ছয় বছর হয়ে গেছে
Hearing concluded, CAV.
deep.
I'm grateful. Sir.
Affidavit of service is taken on record.